So the first seat is for the seat on the North Carolina Supreme Court. Again, that seat is currently held by Justice Paul Newby. And the other candidate for that is Judge Sam J. Ervin IV, who is currently on our North Carolina Court of Appeals. You should all have a brochure or a program that has the question that we have asked them to address, but I do want to read that out as well. The question for these candidates is that in common law legal systems, a precedent or authority is a principle or rule established in a previous legal case that is either binding on or persuasive for a court or other tribunal when deciding subsequent cases with similar issues or facts. The general principle in common law legal systems is that similar cases should be decided so as to give similar and predictable outcomes. And the principle of precedent is the mechanism by which that goal is attained. Black's Law Dictionary defines precedent as a rule of law established for the first time by a court for a particular type of case and thereafter referred to in deciding similar cases. Our economy in North Carolina is increasingly becoming national, if not international. What is your view of considering case law from jurisdictions outside of North Carolina? And what about outside of the United States? Now, we again have the seats based on seniority, and then the candidates have just been scheduled in alphabetical order. So we would now ask Judge Sam Ervin to come and speak to us. Thank you, Judge.
It's a great privilege for me to be here this afternoon. It's been nice to see so many friends that I've known over the years, and I appreciate the organization's willingness to have this forum. I want to talk with you not so much about the kinds of things that I put in the background materials that are in the program and in the Defender article that we've all been allowed to write, but rather to talk a little bit about myself as my career, how it relates to the question that we've been asked, and to hopefully give you some sense of what my career has been, what qualifications I bring to this race, and why you should consider voting for me. Like many of you, I have spent almost all of my life in some form or another as a litigator or as somebody involved in administrative or judicial litigation. I worked for 18 years in private practice. During that time, I tried all kinds of cases to juries, almost exclusively in the state courts, not the federal courts. And we're talking about serious felony cases, business disputes, personal injury cases, administrative litigation, real property litigation, just about anything. So I at least understand what it's like to be a litigator in the courts in the state of North Carolina. And what I've learned from that experience was a number of things that I think are important to my work at the court and to who I am as a person. The first is the importance of high-quality representation of clients to both the clients themselves and also to the judicial system itself. It's much easier as a judge, and I found it much easier as a lawyer, to deal with cases in which counsel did a good job. That makes everybody's life easier, and I learned that. I learned, for example, that the rules of civil procedure are there for a reason, that Rule 12b-6 exists for a purpose, that not all issues of fact are material, and that there's great importance in having consistent, predictable decisions by both lawyers themselves, believe it or not, and also by courts. I also had a great deal of experience representing and handling cases involving businesses. At my firm, I tried any number of business cases. As some of you know, I spent many years on the Utilities Commission. Before that, I represented a coalition of manufacturers who were interested in what happened before the Commission. Anybody who sits on the Utilities Commission cannot help but be aware of the fundamental transformation that the economy of this state has undergone in the last 20 years and what implications that has for the legal system and for the practitioners in our courts. It's hard to describe how much different the economy in this state is now from what it was when I started practicing law in 1981. And I think it's important for the courts to recognize that fact. I've also had substantial experience writing business cases on the Court of Appeals. Some of the opinions that I've written that you may be familiar with are Hill versus StubHub, which dealt with whether StubHub was guilty of scalping, a Fifth Third Bank case which dealt with liability for lenders, and other decisions of that nature. Those cases and the changes in the economy reflect what the question that we've been asked relates to. I think it's got a pretty simple answer. The first is that there are some instances in which you're required to consider out-of-state law. Choice of law rules dictated in some instances. Secondly, a not very well-known statute, GS 4-1, provides that the common law is in effect unless superseded. And where did the common law come from originally? And then lastly, there are occasions in which precedent from out of state can be helpful, persuasively, not as binding authority. Not all precedent from other jurisdictions, either within the United States or within our state, other states in the Union, is necessarily all that helpful. You need to look at it, and you need to think about what kind of jurisdiction did it come from. Did it come from a jurisdiction comparable to the one that we live in? How well written is it? How consistent is that decision with other decisions covering the same subject from other jurisdictions? There are a host of considerations that need to be taken into account in looking at extra-jurisdictional law. But to say that you would never consider it, I think, is both inconsistent with the decisions of the Supreme Court and our court, and probably a mistake. After all, a judge should get whatever help that judge thinks he or she needs, and if you can get some help from precedent outside your jurisdiction, why not take it? Ultimately, I think the decision that you have to make in terms of voting in this race should be based on looking at the records of the candidates. I've got an extensive record at the Utilities Commission and at the Court of Appeals. I've written hundreds of decisions at the Court of Appeals at this point. It's very hard not to think that you know that I'm a known quantity. I ask you to look at those decisions. I think you'll find that they're fair, impartial, thoughtful, thorough, and they don't show any political or ideological agenda. I would ask for your support. I believe that I'm the best qualified candidate in this race. It's great to be here this afternoon. Thank you again for having us. Nice to see you.
If there was ever any question about the importance of an independent tribunal, just think of what's been going on with the NFL the last weekend, okay? Need fair and impartial judges. Over the last 8 years, the lodestar of my jurisprudence has been the law needs to be fairly impartially applied, consistently, predictably, and concisely. It's so important for the business community, for the legal community, that we as appellate judges make it easier for you when you sit down with your client, when you sit down with your attorney, to have a high degree of predictability about what a court will do under any circumstances. Over the last 8 years, I've written more opinions than anyone else on the Supreme Court, almost twice as many civil cases. In light of that, I have the widespread bipartisan support, including 4 former Chief Justices, 2 of each party. I'm also grateful for the endorsement of the political action committees of both the North Carolina Association of Defense Attorneys as well as the North Carolina Chamber of Commerce, which for the first time in its history also endorsed a judicial candidate. I've been selected to provide continuing legal education to judges and lawyers as well as law students. I teach about the North Carolina Constitution. I've written a book. And this past year I received the North Carolina Constitutional Rights and Responsibilities Award. I've tried to be a good ambassador for the court these last 8 years. Civic education is very, very important. I go into the public schools frequently. I also speak to civic groups. The most frequently asked question I get there is, oh, you're just on the Supreme Court, never met one before. Can you help me with my speeding ticket? We got a lot of work to do with regard to civic education. Because of my work with civic education as well as Boy Scouts, I'm an Eagle Scout and work with Scouts around the state and teach Citizenship Merit Badge. Because of that, in 2011, I was honored with the Citizen Lawyer Award. I've also been selected by the Open World Program to host international lawyers and judges and teach them about the American system and what it means to truly have the rule of law with which we are blessed. A little bit about my background. I grew up just down the road in Jamestown. The only 4 years I ever spent out of state were the 4 years I went to Duke, and then I went to UNC to law school. I started out with a transactional practice with the Van Winkle law firm, did all types of represented businesses, and then I was corporate counsel. In 1985, I became an assistant United States attorney where I did both civil and criminal litigation. With regard to civil litigation, I defended all kinds of personal injury actions, including medical malpractice. I did secured and unsecured transactions. I did employment law, as well as complex real estate and business litigation. In 2004, Justice Bob Orr resigned from the North Carolina Supreme Court, and I was fortunate enough to be elected in his position. The essence of the question that is being presented to us is, at what point do we need to look to other jurisdictions as we develop the case law in the state of North Carolina? Again, the lodestar, predictability, consistency, being clear and concise as we help establish the law. The bedrock of commercial activity, the bedrock, if you will, of our legal practice is predictability. It is essential that businesses and lawyers know what the law is. It's our job as appellate judges to help in that endeavor. The jurisprudence that I bring to the bench is shaped by my practice. When I would sit down in a transactional situation or when I would litigate an issue, if the law were not developed well in North Carolina, I would look at other jurisdictions that had considered similar issues, whether in drafting or whether in deciding to settle or go forward with litigation. I'm going to give you some examples of my jurisprudence over the last 8 years where I have either utilized or not utilized outside decisions. First off, when it's well developed in North Carolina, we simply don't need to look outside the state. In Stark versus Ford Motor Company, where we reversed the Court of Appeals, I wrote an opinion that had to do with the interpretation of the term party with regard to third-party actions as defenses in these products liability cases. I said that the party simply meant someone other than the manufacturer or the seller. Likewise, in Shaw versus U.S. Air, again, this was a workers' comp case. Our law was very well developed. I didn't need to look outside of our jurisprudence to say that an employer's voluntary contribution to a retirement account was not part of average weekly wage. Looking at situations where we do need to look at other jurisdictions, certainly any time it involves the UCC, any time it involves interstate commerce, we don't want to be an outlier. The parties would have considered the way that various provisions have been interpreted. I don't have time to go into them. The Skinner case with regard to personal jurisdiction, Tillman with regard to the Federal Arbitration Act, Harleysville having to do with interpretation of standard insurance policy provisions. Again, something that's done in every state. We want to interpret it consistently with that of other states. The Hamby case, which had to do with LLC protection, although it was developed under Delaware law, our law, North Carolina law, tracked it very carefully. Again, the lodestar, predictability, consistency, clear and concise. I believe if you go back, you read my opinions over the last 8 years, you'll see that I have achieved that, and I ask for your support to continue to serve the people of the state of North Carolina. Thank you.